Hello and welcome to Legally Speaking with me, Tarun Nangia. Today we are going to discuss a subject which is important for any healthy democracy. The subject is democracy, courts and the rule of law. Our panelists for this discussion are Justice A.K. Sikri, Judge, Singapore International Commercial Court. He's also a former judge of the Supreme Court of India and the incumbent chairperson of the News Broadcasting Standards Authority. Justice Michael Wilson, sitting judge of the Hawaii Supreme Court, USA. He was appointed to the Supreme Court after having served as a circuit court judge of the First Circuit since May 2000. We have Justice Matthew Cooper with us. He is a justice of the New York County Supreme Court, USA. He is the chair of the Board of Justices of the Supreme Court, First Judicial District. He is also on the executive boards of the New York State and the New York City Associations of the Supreme Court Justices. Professor C. Rajkumar is with us today on the show. He is a well-known public intellectual and the founding Vice Chancellor of the Jindal Global University. A Rhodes Scholar, Professor Kumar has academic qualifications from the University of Oxford and Harvard University. So as you can see, we have a diverse panel. We have people from the academics, as well as somebody who set up a university. We've got a former judge of the Supreme Court who's also now with the Singapore International Commercial Court, as also we have judges of the Supreme Court from America. Let's begin our discussion today. I'll start with Justice A.K. Sikri for his opening comment on the state of affairs between democracy and judiciary. Sir, your opening comment.
You see, over a period of time, if we see the history, there have been different kinds of systems how the society is to be governed. It is not necessary to go into all that debate. But what is important is that in last 150 to 200 years, or even little over 200 years, if we give the example of US, the constitutionally governed democracies have come up. And the trend got momentum after the Second World War. And the Holocaust which it created, and it was thereafter felt by various countries that look, there should be systems which should be governed by some written instruments. And over a period of time, and many countries now, more than 100 countries, have their own written constitutions. Now, in almost all these constitutions, you will find that they have to be democratically governed. In very simplistic terms, if we say that the democracy is where the people elect their own representatives and the majority rules. But the decision who should be the ruler or the governance should be at whose hands, that is to be decided by the people of the country, and in a particular country, that the society which decides it. And therefore our constitution also, like US constitution, it says in most of the constitution, we the people. Even the constitution is created by the people for themselves. Now, as I said, that this is a very simple way of narrating what the democracy is, that it is the governance by the people, for the people, and for themselves. But then at the same time, it is only not limited to this, that the elections take place, the people vote, and the people, whichsoever political party is majority, that forms the government, and that would rule. But then at the same time, the constitution and all constitutions, including of US and India, there's a system of governance there. There are some parameters which are laid down how the governance would take place. And we know in almost all these democracies, there are three pillars of the state which they are known as. This legislature, which is one which makes law, executive, which enforces the law, and which implements the law, and the judiciary, which enforces the law. So the these pillars of the state, it is also like in our constitution, it states that both will their rights, their powers, etc. are defined in the constitution. So they have to work within the limits which are defined in the constitution. And we have the system of separation of powers as well, that one wing of the state would not interfere with the work of the other wing of the state. At the same time, in this entire process, and without giving this thing in detail, which we'll discuss later, but then at the end of the day, in the Indian Constitution, which we again concept which we took from United States Constitution, was that is of judicial review. That is that ultimately it is the judiciary which has to a judge, if it comes as a judicial review, whether a particular legislation enacted by the parliament or the state legislature is constitutionally enacted or not, or whether this is called judicial review of legislation, and whether a particular act by the executive is legal or not. This is judicial review of administrative action. Yes. So therefore, ultimate power is given to the judiciary. And in this, as I said, that there are checks and balances, in the sense that one limb of the government checks the other limb of the government, all that is provided. So this we can say broadly, can state is the way the democracy functions. But as I said, when we proceed further, we'll try to deal with other nuances as well.
Okay, interesting comment. Justice Wilson, your opening comment on the state of affairs in relation to democracy, judiciary.
Thank you, Tarun. And being in India provides a context for this idea of democracy and the judiciary. Because, as Justice Sikri pointed out, there's been a long history, hundreds of years with respect to the United States, of the idea of the rule of law applying by the judiciary to make sure that the laws are being followed by everybody, regardless of the power that they have or the wealth that they have. The laws have to also be followed by the legislature, and they have to be followed by the executive, and the courts have the great opportunity and the responsibility to define what it means to follow the law. But if you move into a contemporary context, what is democracy in terms of the rule of law now if it isn't seen from an international perspective? Because so many issues have become broadly international. And part of the reason that my brother Justice Cooper is here and I'm here is to get knowledge and to some extent leadership about these very important international issues. Because if you think of what the future is going to be like and the court's role, take surveillance, for example. Yes. The idea of power being given to government that is absolutely beyond any precedent, the power to keep track of every citizen. Yes. Well, if we are to be concerned about freedom and the freedom of individuals under a constitution, and our constitutions are very similar, they both have a focus at the beginning on we the people, so the democracy is supposed to be power that comes from the people. If we're concerned about the everyday quality of life, well, courts are going to have to decide how much can a person be surveilled in the future. This is a role of courts internationally. And finally, if you take the 850 million people that are of an age less than 30 in India and look at their future, 50 years from now, when, for example, Bangladesh has to be evacuated with 160 million people, there'll be so many issues that are international that a great Supreme Court like India will have to face to some extent before our courts in the United States, because India just happens to be on the cutting edge of that very, very serious issue of climate change. Yes. So contemporary democracy, contemporary judiciary means to some extent now we have to be thinking internationally and thinking together.
Some very interesting points by Justice Vincent. Now I'll go off to Professor Rajkumar. You had someone who have had the experience of staying in about 3-4 countries. As far as I know, you've spent time in Hong Kong, America, and the UK, and experienced democracies in these countries, especially because you're associated with the field of law. How would you look at democracy in relation to judiciary and rule of law in different countries?
So, I mean, as our distinguished judges said, that at least in the Indian context, we never had a choice of not having a democracy. The founders of our republic were very conscious of the fact that they were trying to create a society which was so diverse, so much of inequality, so much of different religions and castes and languages. So democracy became an opportunity for binding people. And so there was no choice whatsoever. For India, it's not a choice to be a democracy. It's an imperative that India can be nothing but a democracy. But having said that, the founders were also very conscious of the fact that they were participating in the freedom movement, and they were resisting, what was another democracy in its own right, and which was implementing an authoritarian form of governance in India. And it was ruled through law.
Yes.
And so when they were writing the constitution, they were conscious of the fact that they were actually creating a constitution for themselves, but at the same time, they were creating a situation whereby those people who are going to hold power within that constitution should be made accountable as well. And it was quite an extraordinary moment, because rarely in history where the people who are writing the constitution are also directly involved in the creation of a new republic and will also be the early holders of that power. And so because they participated in the freedom movement themselves, were conscious of the autocratic and undemocratic rule that they were witness to, they were very conscious of infusing a lot of provisions in the constitution which protected rights and ensured freedoms. But also they recognized the role of the courts. And that made it so, in many ways set the tone for how the relationship between the legislature, the executive, and the judiciary will be. And of course, it took many more years later in the functioning of our democracy for us to determine what is the nature of the relationship, because clearly, if you look at the UK context, Parliament is supreme, but India went through a lot of evolution for us to ultimately determine that actually in India, it's not the courts are supreme. It's not the legislature. It's not it's the constitution which is supreme. And that is an evolutionary idea, and in many ways also a revolutionary idea for it to have deeply embedded in the political and the civic culture of India.
Interesting point, as I see, made by Professor Kumar, also because if you see the kind of countries that got independence in South Asia, how many of them are democracies today or masquerading as democracies today? We all know that, but that's another discussion. Justice Cooper, your comment on this important issue.
I was hoping that you'd have me speak after Justice Wilson, because it's always very hard to sound smart after Vice Chancellor Kumar speaks. He's so brilliant, but I will do my best. And this is, unlike Judge Wilson, is my good friend. This is my first visit to India.
Yes.
Justice Wilson has been many times, and my wife and I have been struck by so many similarities between India and the United States. These are vibrant, swirling, not often tidy democracies. And I've also been struck by the significant major points in governing that we share. Above all else, we are two nations that have written constitutions. We have the oldest written constitution. You have the privilege of being the largest constitutional democracy in the world. And the things that I've learned, other than, of course, that we start with the same preambles, we the people. We have a very powerful 14th Amendment to our Constitution. About a great deal of our social change has come through court decisions that have applied the 14th Amendment. You have Article 21 of your Constitution, which certainly envelops major concepts that we find in the 14th Amendment. But I think, to echo what the other members of this discussion have said, is that unlike other countries, our two nations have a commitment, and hopefully will continue to have the commitment, to having three branches of government that are co-equal. We recognize how important it is to have checks and balances. Both our countries are faced often with challenges where those checks and balances might be called into question. And we have system of government where the ultimate body that determines what that Constitution says, the ultimate body that interprets the Constitution, is our Supreme Courts. In our case, Supreme Court of the United States, and yours, the Supreme Court of India.
I'll go to Justice Sikri. Sir, I want to know from you this specific thing on, now in India at least, as I have seen, and I can speak from the Indian Express, that our Supreme Court has been called upon to tackle different types of crises, from water disputes between states to midnight formation of governments. And courts have come to the occasion. We've covered midnight hearings at 4:30 a.m. in the morning, and there
was a party to one of that.
and sir, there is a sense that that I get when I speak to people across the country, especially who are from the government, that the easiest way not to decide something and absolve myself from the responsibility is just toss it to the courts and let them decide. So when the executive, when it doesn't want to work, just put the ball in the court's court and let the courts decide. Do you think the courts are being made to do things which wouldn't have been, in a sense, expected of them to do, but now they are doing everything from policy making to the kind of disputes? But you're the best judge, so I want you to
let me deal with this this issue which you have thrown open in two ways.
Yes.
One is where we left, all of us, in our preliminary round when you asked the first question.
Yes.
And so in this entire context, and what are the conditions in which we are going, and what is the international scenario, as Justice Wilson also pointed out, how the Indian Supreme Court has evolved,
Yes.
and then come to the issue which you have raised, because there would be some connect between the two. Now, we were talking about democracy and the role of courts in that. You see, one simple way, as I said earlier, what is the role of the court to decide the dispute between the parties which are filed in the courts. So, but that would be a simplistic view, as I said earlier, and going by what our constitution expects from the judiciary. When we talk of democracy and when we talk of rule of law, I would say that the first and fundamental role which is assigned to the judiciary is to uphold this democracy and to uphold the rule of law. So that has to be in all given circumstances. Other role which is ascribed in Indian context, and it is relevant in many countries, and it may be in a different context, but may be relevant in the case of US also. And going by the fact that in 1947 when we got independence, and in 1950 when we gave ourselves this constitution, India was one of the poorest countries, and poverty is still there. So we have marginalized people, we have deprived people in our society. So therefore, over a period of time, and having regard to the chapter on fundamental rights, which was pointed out by Professor Rajkumar, and another chapter on this directive principles of state policy, and how this has been interpreted over a period of time, and many aspects of directive principles which are not enforceable otherwise have been brought into the contours and scope of the fundamental rights, particularly Article 21, and how those have been enforced is a enlightening history, and where the contribution of the Supreme Court is remarkable. But what I am saying is that second role from this, first role I said to uphold the constitution and the rule of law. Second role is here it comes to bridge the gap between the law and the society.
bridge the gap
Between the law and the society, wherever this gap is there. So that is the role over a period assigned. Now what happens actually, now third dimension which we feel now is happening particularly in last few years in various countries, and I'll include US and India as well, is the kind of, you see, we started, as Justice Wilson said, that today international, we have to see it from international angle. There are boundaries, geographical boundaries are getting blurred, etc., particularly after globalization. But at the same time, a parallel thing which has started at least in last couple of years is, and particularly after 2008 when there was an economic recession in the world, parochialism has again been brought into.
Yes.
In many countries, they feel that, look, no, we have to first take care of the people from our country. And so I'm not, I think I'm very clear in when I'm saying so, and I'm not giving the examples, etc. Now, on the one hand, we talk of liberal democracies. So in a liberal democracy, the power of the state is limited.
Yes.
Right? Even if it is an elected government, so majoritarianism would not rule in that sense. Minorities also, and the other section of the society also have a right to say in the governance. That doesn't mean that they are totally deprived of it. Now, Hobbes had given us the social contract theory,
Yes.
where he had created a Leviathan state, if we see. And the purpose was, the objective behind his Leviathan state was that, look, if we don't have, and that is how the democracies came into being, we don't have an organized society, and in an organized society, it would be Jungle Raj, and the mighty person with this can rule and say, so therefore we can't have that kind of anarchy. So that is why he said Leviathan state, where it would be people would elect their representative who will govern. But at the same time, the state, and these are some of the stories in last few years, if you see Turkey, Libya and other countries, where the state also become despotic.
Yes.
So therefore, how to control that? So that new theory which is emerging and which is now projected in last couple of years is that we have to have a state. The state has to be there in a democracy which should rule, but then it should be a shackled state.
Shackled state.
Shackled is the expression which is used. It should be a shackled state where society should have a right to project its voice even against the elected government, if elected government is not going ahead and as per the constitutional norms, etc. Now, having said so, in our Indian context, where of course now recently in a different context, there's so much of protest, etc. I'm not going into the merits whether protests are good or protests are bad, but then over a period of time and in Indian context where people have not been able to raise their voice otherwise, it was, and the history has shown that it is left to the judiciary.
Sir, if I may
Now, in that
interrupt.
context, I come to your second aspect, which you
Yes.
said. Should I answer that
No,
just now?
just before you answer, I want to
yeah,
briefly interrupt you.
yeah,
Professor Kumar raised an interesting point when he said that it's not the judiciary which is supreme or the parliament, it's the constitution which is supreme.
Exactly.
Would you agree with his?
Yes, yes. I agree 100% with him because even it's not only the legislature or the executive which has to function within the framework of the constitution. That is the duty of the courts also. That is the duty of judiciary as well.
Okay.
As I said in my opening remarks, that the scope and the powers of all the three
So
wings
you're
of the
in
state.
agreement with the theory?
Oh, yes, yes, completely in agreement.
Yes.
But what I said was, and that makes important is, ultimately suppose if a particular law is enacted, I'm giving an example, by the parliament, and the validity of that law is challenged.
Yes.
Now, in the court, the government would come, Union of India would say that no law which is passed is constitutionally valid.
Yes.
Right?
Yes.
The person challenging would say that no, it is not because it offends, say, Article 14, Article 19 or Article 21 of the Constitution or any other provision of the Constitution, or it is ultra vires. It was not within the powers of the parliament to enact such a law. This power is given to the state legislature, etc. So these are the grounds on which a law can be challenged. But then who is to decide? Here judiciary comes
So you mean
in.
judiciary?
So therefore last word is with the judiciary.
This is the last word, but you're not saying that judiciary is more powerful? Or
No.
It's the constitution which is
It
powerful.
is constitution which is powerful.
Yes.
No doubt about it. Now
answering my question.
yes, now I come to your question which you asked me, that the tendency has become, you see, there are, as I said about directive principles of state policy. Now, directive principles of state policy are various principles enshrined in that chapter, as per which they lead towards good governance. They are aimed at creating an ideal society, equalitarian society, which is more, economically also, which gets more prosperous, etc. That was the aim, as Rajkumar rightly pointed out while of the framers of the Constitution.
Yes.
Now, those are the duties which are cast upon the executive, that you frame such policies which are good for the people, for those who are downtrodden, those who are marginalized section of the society, their standard of living, etc., should be raised. There, all kinds of this are there. Now, executive, over a period of time, it was seen, has failed.
How?
That is the perception of the people, that the executive has failed in its duty
Yes.
to bring about. I'm not at all commenting that, look, from in last 70 years, there has been a lot of progress made by
Yes.
India, economic progress, and on social front also. So credit of this goes to executive as well, the
Yes.
government as well. I'm not saying that. But in many ways,
You mean there are aspects
yes,
where there are grievances?
yes, there are grievances. Yes, there are aspects where there are grievances, and it started, say, in of course, in 70s, and when we have that, we call it a socialist era, when we had justices like Justice Krishna
Yes.
and Justice Bhagwati and Justice Chinnappa Reddy, etc.
Yes.
And this is called socialist period that for social rights,
Yes.
in that sense. So therefore, those kinds of causes started coming, and Justice Bhagwati, he started that public interest litigation, which is called social action, litigation as
Yes,
far as
yes.
US is concerned. So at that time, it was thought that, look, there are some of the unprivileged section of the society, but because of their poverty or because of their illiteracy, they are not able to bring these causes. The court started doing
So, you
this.
mean what you are indicating, that there are grievances which the courts, people came for the courts for redressal, and courts where it was not suo moto.
Yes.
It's people who went to the courts,
Yes.
and then of course the courts kept on
Yes.
getting involved
Yeah,
because people saw results.
And to some extent, although they went, but initially it was suo moto as well.
Suo moto
Because
as
in
well?
PIL, the courts also started taking up those issues.
Okay.
A particular news item appears in the court. If you see the history of 80s and 90s, now we have many public spirited persons
Who are doing PILs.
who are doing PILs.
Earlier it
So
was suo moto.
one day, some incident takes place, you see, within 24 hours, less than 24
There are
hours, writ
PILs.
petition is filed in the Supreme Court
Yes.
challenging that action.
So earlier it
we are
was not
very
the case.
But earlier it was not, in 80s, etc. It is the court which gave impetus to this as well. And so what happened,
Yes.
then you see that if we see the history of PILs,
Yes.
public interest litigation, or the kind of litigation, we'll call it, and it is stated also in one of the judgments in 2010 by
Yes.
Justice Dalbir Bhandari,
Yes.
State of Uttarakhand versus Balwant.
Yes.
He has said that 3 phases of PILs. First was this phase, that for unprivileged class of people who can't come to, and the scope of locus standi is extended. And so therefore the courts, any public spirited person who is not concerned with that case, but he can come and
Yes.
file a case on behalf of others. And the courts can also take up the suo moto. And not only that, you can, in order to see that the procedure should not be, the normal procedure of filing petitions, etc., was also given a go by.
Yes.
You can even write a letter and post it and write it to the Supreme Court.
That's
Supreme
also
Court will treat it as a petition and all. So this was the first phase. Second phase, if you see, which happened when the environmental laws relating to environment, that our ecology, our protection of forests, protections of these rivers, etc. And there's so many judgments of that kind which the Supreme Court started adopting because
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.